Competition Act 2010. What does it mean for your business? The Competition Act 2010, CA, came into force in Malaysia on the 1st of January 2012. This legislation has substantive impact on the way businesses operate. Some practices that were previously common, especially amongst certain groups such as trade associations, including price fixing, sharing of market-sensitive information, market sharing, agreeing to limit production or supply, bid rigging, are now prohibited under the CA. What does the CA cover? The key prohibitions under the CA are as follows. 1. Agreements which have the object or effect of significantly preventing, restricting or distorting competition in Malaysia. This is referred to as the Chapter 1 prohibition, and covers both agreements between competitors, horizontal agreements, and agreements between enterprises operating at different levels of the supply chain, vertical agreements. 2. Conduct which amounts to the abuse of a dominant position in a market in Malaysia. This is referred to as the Chapter 2 prohibition, which prohibits a dominant enterprise, a market share above 60% is indicative of dominance, from engaging, whether independently or collectively, in any conduct which amounts to an abuse of its dominant position. Abusive practices include imposing unfair pricing or trading conditions, predatory behavior, refusing to supply a particular customer, etc. However, where there are reasonable commercial justifications or the conduct represents a reasonable commercial response to the market entry or market conduct of a competitor, such conduct would not fall foul of the CA. Over the passage of years since the coming into force of the CA, the Malaysia Competition Commission, MyCC, has conducted numerous investigations into various enterprises and their practices. One of the recent findings of infringement is the case of Grab, wherein MyCC issued a proposed decision against Grabcar SDN-BHD and MyTaxi SDN-BHD, collectively referred to as Grab, for abusing its dominant position in the relevant market under Section 10 of the CA by imposing a number of restrictive clauses on its drivers which prevented its drivers from promoting and providing advertising services for Grab's competitors. MyCC proposed to impose a fine of $86 million against Grab and a daily penalty of $15,000 per day in the event Grab failed to take remedial actions as directed by the MyCC in addressing the competition law concerns. This decision is not final and Grab has a right to present its defense under the CA. Penalties and liabilities. Infringing competition law can have extremely serious consequences both for the companies and individuals concerned. Crucially, the fines for infringing the CA is significant and is up to 10% of worldwide turnover of the enterprise over the period during which the infringements happened. It is important to note that the fines are likely to be assessed based on the turnover of the group of companies concerned. Further to the financial penalties, there are numerous criminal provisions for obstruction and breaches of the CA, including individuals or bodies corporate who obstruct the MyCC's investigations, or make threats or reprisals against companies or individuals either making complaints to the MyCC or cooperating with the MyCC in any investigation. A body corporate which commits an offence under the CA will be liable to a fine of up to $5 million, while a second or subsequent offence will result in a fine not exceeding $10 million. Where the offence is committed by an individual in relation to the first offence, this will result in the imposition of a fine not exceeding $1 million or imprisonment for a term not exceeding 5 years or both. A second or subsequent offence will result in the imposition of a fine not exceeding $2 million or a term of imprisonment not exceeding 5 years or both. Market review for service sector in Malaysia, wholesale and retail for selected product, WRT sector. Section 11 of the CA empowers the MyCC to conduct market review on any market in Malaysia to determine whether any feature of the market prevents, restricts or distorts competition. Accordingly, the MyCC conducted a market review on competition in Malaysia's services sector, focusing on wholesale and retail trade of selected products, and has quite recently published its final report on the 20th of August 2020. One of the main objectives of the market review was to evaluate the prevailing industry practices and conduct of companies engaged in WRT sector to identify anti-competitive practices in that sector. As the WRT sector covers a wide range of segments, the MyCC has focused this review on the following segments, namely, food and beverages, processed, household cleaning products, personal care and toiletries and clothing. According to the report, a number of competition concerns have been identified in these sectors such as 1. Price fixing. MyCC has observed that there are price fixing practices both in the horizontal level and vertical level. It should be noted that whilst horizontal price fixing between competitors is a hardcore offence and will be deemed illegal per se, Vertical price fixing, such as agreement between a supplier and its distributor, is not, although it may still fall foul of the CA. MyCC noted that there are price-fixing practices in the WRT sector and the practice of supplier dictating the resale price of goods and services sold by its distributors may harm competition and decrease consumer welfare. 2. Price flexing. MyCC has noted that some suppliers sell the same products at different prices, conditions to different buyers or markets. 3. Exclusive distribution. MyCC has noted that some large retailers have exclusive distribution arrangements with suppliers. The potential anti-competitive effect of such practice is that the pricing and availability of such product may be affected and customers may find it harder to source for the products in the areas with exclusivity arrangement. 4. Loss leader. MyCC has observed that some large-scale retailers price certain products below costs to boost the sales of these products. In this regard, such practice may be anti-competitive when a firm with market power lowers its price and intentionally incur losses in order to drive out potential rivals or existing competitors. 5. Bid rigging. It was observed during the market review that some companies collude to choose the winner during a bidding process whilst other market players intentionally submitted incompetitive bid. 6. Tying and bundling. Tying is the practice of selling a particular product, service on condition that the customers also purchase another product, service which are unrelated with the first product, service. This practice may reduce consumer welfare if customers are compelled to purchase products or services that they do not need. MyCC observed that various businesses provide product or services on condition that the customers purchase other products or services. Arising from the market review on WRT sector, MyCC has identified possible competition concern areas and will be taking steps to address these issues, including further investigations into these sectors and practices. MyCC has indicated that the market review study is preliminary and the study will set the stage for specific areas that require focus moving forward. What does it mean for companies? In light of the above, it is important that companies should be aware of the CA provisions and take the necessary steps to ensure compliance. Employees should be made to understand their obligations under the CA, as companies are liable for the action of their employees. It would be prudent that companies have an effective competition law compliance program which can prevent or minimize the risk of competition law infringements arising. Compliance program is recognized as a potential mitigating factor by MyCC under MyCC's published guidelines. To know more,